Hello everyone, I am Dr. Pangal Singh Bisain, Associate Professor at Department of Law, School of Legal Studies, Central University of Kashmir. Today we are going to discuss one very crucial and very sensitive area of law, the protection of children from Sexual Offences Act of 2012, also commonly known as the POSCO Act. Now, this legislation was enacted with a single powerful goal, that is to create a safe and secure environment for every child in India. Therefore, this law recognizes that children are not just immature adults, they are also vulnerable. They are, and therefore, since they are vulnerable, their rights deserve special protection. In this session today, we will break down the law, understand its key provisions, and see how it works to deliver justice while ensuring that child's dignity and mental well-being are also preserved throughout the process. Now let's begin with this important statute. Before we begin, remember one thing, that there are 42 sections in total, and we shall discuss some important sections in detail, and we shall have a kind of a highlight or an overview of the remaining sections, right? So let's begin with the first slide. I think, I hope the slide is visible to all of you. Okay, the introduction part. Now, before 2012, India did not have a comprehensive statute as such that dealt with sexual offences against children. There were provisions in Indian Penal Code, now referred to as Bharatiya Nyaya Sanhita. So, under Indian Penal Code, Section 354 and Section 376 dealt about sexual offences against children. But they were not specifically tailored to children's specific needs and vulnerability. The POSCO Act, now I'll refer the statute as POSCO. Okay. So the POSCO Act was enacted in June 2012, and it came into force in November 2012. November 2012, 40 to be more specific, 14th November 2012, that is celebrated as Children's Day. Now, this shows government's commitment towards protection of children. This act was a response to, let's say, rising cases of child sexual abuses, a need for gender neutral laws, that is, the laws which would protect both boys as well as girls. And at the same time, there was one international obligation also in place. The international obligation, that is a United Convention on Rights of the Child, which India had ratified in the year 1992. So India had to enact some legislation, some law in compliance with this international convention. Now, who is a child under the POSCO Act? Right? The definition of the child. So, Section 2, Clause D says that child means any person who is below the age of 18 years. Now, this definition is absolute and universal in nature. Therefore, there is no distinction based upon, let's say, gender or background or consent and etc. So, even if a child consents, the law treats it as a, let's say, statutory rape, because the law presumes that child cannot give informed consent to any kind of sexual activity, right? One of the most progressive features of POSCO Act is that it focuses on child sensitive procedures. That is something that we are going to discuss. So, child sensitive procedures. And these procedures are very much crucial to avoid uh, traumatizing, or rather, I would say, re traumatizing the child during investigation and trial before the competent authorities. Now, I'll give you a highlight about some of the sections, right? And we'll discuss these sections in detail later on. So, section 24 talks about statement to police. For example, we are talking about some of the procedural aspects of the act. So, section 24 talks about a statement to the police. So, a child's statement should be recorded at their residence or at the place of their choice only. That is given under section 24. Again, it must be recorded by a women police officer, preferably not in uniform but in plain clothes. This women police officer should be in plain clothes while she is recording the statement of a child. The officer must ensure that the child feels safe and comfortable at the time of recording of the statement or afterwards as well, right? So the child should be felt safe and comfortable, avoiding any kind of, let's say, intimidating kind of an environment, right? This is section 24. Now there is another section, that is section 26, that talks about recording of evidence. So the section says that the evidence of the child should be recorded within 30 days, right? 30 days of the offense that has been committed against the child, within 30 days. The child may be allowed video conferencing, especially during cross examination, right? The court may be closed, right? While recording such statement or carrying out the cross examination, the court may be closed and the child's identity is strictly protected under section 23, right? The court may be closed means the court will carry out the procedure, kind of an in camera proceedings, right? So again, the identity of such a child victim should be kept a secret, right? It should be strictly protected. Now, section 33, clause 7 of the statute talks about special courts. Now, courts are directed to ensure that the child is not called repeatedly, right? Not called repeatedly to give his testimony or to record a statement before the court of law. That is something that the court needs to take care of. Again, at the same time, the court has to make sure that the child does not see the accused during his testimony, right? He should not be brought before the accused except under exceptional circumstances, right? If at all he is required to be brought before the accused person, then a screen or a separate room or some kind of a curtain, a shield can be arranged by the court of law. Let's take an example and try to understand the situation in POSCO Act. Imagine a 13 years old boy, right? Let's say he is a victim of sexual assault. Now, under the POSCO Act, first he gives his statement at home, and the statement is recorded by a female police officer in the plain clothes. The authorities are required to give him proper counseling and support at the time of recording of the statements as well as later on. His case is to be fast tracked in special POSCO courts. During the trial, a certain separates, sorry, a glass or a curtain or some kind of a shield should be used to separate such child, right, from the accused, and at the same time his identity is not revealed, right, not to the people who are attending the court of law, the people who are not associated with the case, as well as from the media. Now, if you talk about some of the recent developments in the field of uh, Bosco, the Supreme Court directions have emphasized quick disposal of POSCO cases. Now, according to the directions of the Supreme Court, the POSCO cases must be resolved within 6 months. Sometimes it takes more than 6 months to resolve the cases, but this is the direction of the Supreme Court. Now, in compliance to the directions given by the Supreme Court, some of the states are setting up exclusive child-friendly courts, right, with facilities such as play areas and the supporting staff as well. Now, there are some concerns as well. Some people have raised a concern about mandatory reporting and criminalizing consensual relationship between teenagers. Right? We have seen what we are seeing as of today is that the teenagers are very much uh, friendly, or rather, we can say too much close to one another. Right? And in that closeness, in that friendly relationship, they get indulged into some kind of a sexual acts as well. So, criminalizing consensual relationships between the teenagers, among the teenagers, is one of the hot topics before the legal authorities and before the legislators as of today. Right. Now, let's dive into some of the important sections of the statute. Section 3 talks about penetrative sexual assault. Penetrative sexual assault. This is one of the most serious kind of offenses under the Act, and is also kind of central to understanding how the law categorizes several sexual crimes against children. Now, what is penetrative sexual assault as given under Section 3? The word penetrative might make some of you think only of vaginal or, let's say, anal intercourse. But Section 3 of the POSCO Act takes a much broader view. It criminalizes any kind of penetration, including the use of objects or, let's say, oral sex. Here, what Section 3 tries to say, in, let's say, in simpler terms, right, a person is that a person is set to commit penetrative sexual assault if first penetrates, let's say, the vagina or the mouth or the uterus or the anus of a child, right? Or let's say manipulate any part of the body of the child to cause such penetration, or apply their mouth for or apply their mouth to the child's sexual organs. I know these words, these phrases may be uh, quite uncomfortable to listen, but this is something that the law deals with, right? And many a times, such type of cases also appear before the court of law, and there such kind of references are required to be made by the lawyers, right? The lawyers, the public prosecutors, the judges, and the people who are working in the area of POSCO. Right? So, yes, penetrative sexual assault can be wide in nature, can be diverse in nature, right? And it depends upon what kind of sexual activity has been carried out in a particular act. Oral sexual intercourse involving a child is categorized as penetrative sexual assault, which is again a significant step forward compared to the earlier IPC provisions. The earlier IPC provisions kind of did not recognize oral sexual intercourse in the same light as the POSCO does. Now, a question may arise as to why such a broader definition? Now, this the definition given under Section 3 is wider because in many of the cases, the lawmakers as well as the judiciary recognized that sexual violence against children takes many forms which we might not have even heard or which are beyond our imaginations. So the authorities recognized that sexual violences against children takes many forms, not just what was traditionally called as a rape. Right? So children might be abused using objects or let's say fingers or by oral actions. And the law here needs to be expansive enough, right, to cover all those scenarios. Now, if we talk about the punishment is actually given under Section 4. Right? Section 4 talks about punishment for penetrative sexual assault. I think I have not mentioned the section here, but the punishment is given under Section 4. Now, punishment for this kind of an act is minimum 10 years of imprisonment and maximum life imprisonment. Right? Fine may also be imposed, and the court can, let's say, direct that this fine can be paid to the child for their rehabilitation, to the child or their guardians, as the case may be, for their rehabilitation. Okay. Now let's talk about some important case laws, important cases relating to Section 3. In one of the cases, Alok Srivastava versus Union of India, the case is of 2018. Right? Alak Alok Srivastava case, the case of 2018. In this case, the Supreme Court took suo motu cognizance of increasing child rape cases and emphasized strict implementation of POSCO provisions. In this case, the court recommended fast track courts and harsh punishment, especially for penetrative assaults. Right? If we talk about recent updates, then some courts, as today, uh, not as today, maybe between 23 or 24, but some courts have classified that even slightest penetration, whether by, let's say, body part or object or anything, qualifies the act under Section 3. Now, this means the degree of penetration is irrelevant now. The fact of the penetration is enough, right? The fact that the penetration has happened is enough, and the degree is not important as of now. Now, Section 5 talks about aggravated penetrative sexual assault, right? Aggravated penetrative sexual assault. Now, this is, as the name itself suggests, aggravated, right? So, this is more serious and more heinous category of offense, right? This generally happens when the crime isn't just penetrative sexual assault, but is made more worse by, let's say, who is committing the offense and how the offense is committed, and at the same time, who the victim is, right? These are some of the factors which make the sexual assault more heinous, more aggravated, right? What does it mean aggravated in the sentence mean? Aggravated refers to circumstances that make the offense more harmful or more exploitative, right? Especially when committed by someone who holds, let's say, power or trust or authority over the child, right? Power, trust, or authority over the child. According to section 5, an assault becomes aggravated if it involves the people with power, trust, and authority. Now, who can these people be? Right? What can be the examples of people with authority, power, and trust over the child? Then it may be, let's say, the guardians of the child. It may be the police officers. It may be some public servant. It may be armed forces, right? It may be, let's say, teachers. It may be doctors. It may be hospital staff, right? Or any of the family members, and so on, right? These are some of the examples of the people who hold actual power, trust, or authority over the child, right? Now, if we talk about the brutality, because we are talking about aggravated sexual assault, so if we talk about brutality, right, then use of deadly weapons or fire or coercive substance like acid or something, right? And by using these things, causing serious, grievous hurt, right? Grievous hurt, or let's say some kind of major or minor injury to the sexual organs of the child, or causing, let's say, permanent disability, right? Permanent disability to the child's bodily organs, or it may also be committed, the assault may be committed during communal or sectarian violence as well. Right. Then the assault may also happen, uh, and the result of such assault may be, let's say, pregnancy of the child, or transmission of deadly diseases like HIV, or transmission of any other diseases like STDs, sexually transmittable diseases, right? STDs. So these are some of the instances where the sexual assault becomes brutal, it becomes aggravated, right? Now, Section 5 also covers gang penetrative sexual assault as well. So, if an assault is committed by more than one person acting in conscience with one another, all of them are considered guilty of aggravated penetrative sexual assault, irrespective of how they committed the sexual assault. If there are more than one person, then all of them can be held guilty under section, can be prosecuted under section 5 of the statute. Then section 5 also talks about assault on particularly vulnerable children, right? Particularly vulnerable child as well. Now, who can be a particularly vulnerable child? Let's say a child who is mentally ill or physically disabled, or a child who is, let's say, under the age of 12 years, is presumed to be particularly vulnerable child. And anyone who commits any degree of sexual assault on these children can be held liable under section 5. Right? Now, again, the punishment for this offense is given under section 6, not under section 5, but under section 6. And the minimum punishment for this offense, for the aggravated penetrative sexual assault, is 20 years of imprisonment, and maximum punishment is life imprisonment, or in some cases death penalty as well. Now, death penalty was introduced by Criminal Amendment Act of 2018, right? This was introduced after the public outrage following several brutal child rape cases which was coming before the judiciary, before the judicial authorities, right? So it was introduced in 2018 by way of Criminal Law Amendment Act. Okay. Now this punishment reflects the severity of, let's say, betrayal of trust or misuse of power or authority, and at the same time, it reflects the extreme trauma such act causes upon that victim of offense, that is a child, right? Now, in one of the cases, state of Maharashtra versus Suresh Gavit, Gavit, right? State of Maharashtra versus Suresh Gavit. The case is of 2023. The Bombay High Court upheld life sentence for a man who raped 7-year-old girl, affirming that it is an act, uh, it is an aggravated offense, uh, under which is prosecutable under section 5 of the statute, due to the child's age and the brutality with which the act was committed, right? Due to the child's age and the brutality, the act was brought under the preview of section 5 of the statute. Now, let's talk about the next section, section 7, that is a sexual assault, right? Now, what amounts to sexual assault under the POSCO Act? How sexual assault is defined? So, when a person with sexual intent touches the body parts of the child, the private parts of the child, like let's say vagina or penis or anus or breasts of the child, or makes the child touch them or another person in such a manner, or does any act with sexual intent involving physical contact without penetration, amounts to sexual assault. This is a definition. This is something that I have read out of the Bare Act itself. That is Section 7, right? So basically, what Section 7 is trying to say, what it is going to cover, what it covers is that it's about touching or making a child touch private parts without any penetration. What matters the most in these types of situations, what matters the most is the intent behind the act. If the intent is a sexual exploitation, it qualifies under the section. It qualifies as sexual assault. Now let's break down this section a little bit more. Right? Law protects child not from violent rape like situations, but even from the law not only protects a child from violent rape like situations, but it also protects a child from any form of molestation, or let's say inappropriate touching, something that we are learning now. We are teaching to the children as in the schools as of now, that is good touch or bad touch, right? So inappropriate touching, sexually motivated physical contact, right? All these things comes under the preview of POSCO Act now. The punishment for this sexual assault is given under section 8 of the statute. So minimum punishment is 3 years, maximum punishment is 5 years, and fine, right? And fine is also included, right? You can see that the punishment is less compared to the previous sections, right? But while the punishment is less severe than the previous section, like penetrative assault or aggravated penetrative assault, it's still criminal, right? It's still criminal and non-compoundable in nature, showing that the law takes all forms of sexual contacts with children very seriously. Again, I have one more case that is relating to the section. That is Satish Ragde versus State of Maharashtra, the case of 2021. RAGDE. Satish Ragde, RAGDE, the case of 2021. In this case, the Bombay High Court uh, controversially held that skin to skin contact is necessary to constitute sexual assault. Right? Skin to skin contact is necessary. That was kind of a controversial statement that was made by Bombay High Court. And this opinion, or rather a judgment of the Bombay High Court, created public outroar. And there comes the Supreme Court. The Supreme Court swiftly overturned it in Attorney General versus India. Attorney General of India versus Satish case of 2021. Right. In this case, the Supreme Court said that sexual intent is the key, not whether touching was over the clothes or not. This was a landmark reaffirmation of child's right. Therefore, the focus must remain on intent and impact, not the technicalities of the subject. Like technicalities like skin to skin touch or touching the clothes or the layers of the clothes and on. Now, Section 9 of the statute talks about aggravated sexual assault. Aggravated sexual assault, Section 9. Right? With a non-penetrative equivalent, which was given under Section 5 of the statute, that is aggravated penetrative sexual assault. Right? This section punishes more serious or exploitative instances of molestation. Right? Molestation and sexual contact that stop short of penetration. They are not penetration, but they are little bit less than penetration, right? They are a step before penetration. What is aggravated sexual assault? The situations which can be covered under this section, that is aggravated sexual assault, may be the offender is in a position of trust or authority, like the one we discussed previously, that is a police official or the guardian or the doctor or the teacher and on. Then the victim is specially vulnerable. For example, he is below the age of 12 years or he is physically or mentally challenged, right? The act that has been committed is committed with cruelty during communal violence or let's say multiple times. And finally, the assault involves gang assault as well, but not penetrative. Remember this. If it is penetrative, it will fall under different section, right? If it is non-penetrative but still brutal in nature, then it will come under the category of section 9. Now, the act causes harm. Such act that is committed by either a single person or a group of people, that is gang assault, right? Such act causes harm or serious mental trauma to the child. So essentially, if section 7, that is sexual assault, then section 9, that is aggravated form of that assault, uh, due to who, how, or where of the crime is important. Right? The punishment for aggravated sexual assault is given under section 10. Minimum 5 years of punishment, imprisonment, and maximum 7 years of imprisonment plus fine is given under section 10 of the statute. Right? Now, again, this shows that law considers these acts very seriously. Right? That is the reason why it has covered the normal sexual assault as well as aggravated sexual assault under the POSCO Act. In one of the cases, that is in State versus Ravi Kumar, this case was before Delhi High Court, and the case is of 2022. A doctor was convicted A doctor was convicted under Section 9, Clause M for groping a 14-year-old patient during physical examination. Right? During physical examination. Now, the court in this case held that doctors are duty bound to act with highest level of ethics and professionalism and care. Abuse of that position invites strict punishment. This case somewhere somehow shows that the courts are extremely sensitive when it comes to children, right? And the courts are very much keen to uphold the spirit or the basic tenets of POSCO Act, right? Especially in professional contexts. Now, Section 11 of the statute talks about sexual harassment. Section 11. Now, what does this section say? Sexual harassment of a child. A person is said to commit sexual harassment of a child uh, when one person with intention, let's say, utters certain words, or let's say makes certain sounds, or shows gestures or body parts to the to a child, or shows some kind of a pornographic material, right? Or makes a child to exhibit their body or some body parts, right? The private body parts, basically. Or they threaten the child with some kind of sexual act, right? Or let's say even follow or minor acts like following or stalking a child with sexual intent. Here, sexual intent is important, right? With sexual intent may come under the preview of Section 11, that is sexual harassment of a child. So I'll repeat: uttering of words or making sounds towards a child, showing gestures or showing body parts, showing some kind of pornographic material to a child, making the child show their private body parts, right? Threatening a child to commit some kind of a sexual act against him, or following or stalking, all these things, these actions come under the preview of sexual harassment of a child given under Section 11 of the statute. Right. So basically, physical contact is not necessary under Section 11. Physical contact is not at all necessary. It's about sexual advances or exposure or intimidation, even if done through words or gestures or some kind of a technology, right? Technology like showing pornographic material, digital material to a child. So that may come under the category. Uh, Punishment is given under Section 12 of the statute. The punishment is imprisonment up to 3 years, or fine, or both. Right. So there may be an imprisonment of 3 years or fine or both in case of uh, under Section 11, under Section 12 of the statute. Right. Now, in today's world, uh, many sexual harassment cases are occurring online, right? Online, or let's say some digital platforms or digital applications like Facebook or WhatsApp or Instagram, sometimes in the gaming consoles, right? Gaming chat boxes, etc. Right? The courts in India and the police officials, the means the legal system in India are increasingly treating cyber sexual harassments of minors under POSCO Act. Right? Now, digital sexual harassment also comes under the preview of POSCO Act. Section 67B of the Information Technology Act says that showing any kind of obscene material to children online is a punishable offense. But POSCO takes priority if the victim is under the age of 18 years. So POSCO will prevail if the victim of such obscene material is a child who is below the age of 18 years. In one of the cases, the Karnataka High Court held that even a repeated winking, or let's say some kind of vulgar gestures or loud comments towards a child are actionable under Section 11 of the statute. Even if there was no physical touch, no physical approach, even then such kind of actions may be prosecuted under POSCO Act. Okay. Uh, if we talk about the practical application of this section, then this section is generally seen in case of, let's say, school harassment cases, where a teacher or let's say a senior harasses students verbally or with gestures. The such kind of harassment is also seen on streets, right? Like let's say eve teasing, especially in case of a minor, may attract Section 11 or may attract POSCO Act, right? Then again, cyberbullying, right? Uh, Online grooming may come under the preview of Section 11. So this is the relevance of Section 11 in the present context. Now, if we talk about Section 13, that is use of child for pornographic purposes, this Section 13, which I personally think, it covers most disturbing kind of an offense, right? Using children for pornographic purposes, right? Quite disturbing in nature. This section here deals with situations where children are exploited not just through abuse, but also capturing and distributing their images and videos, distributing for some kind of a sexual gratification, some kind of a monetary benefit. Now, what does Section 13 prohibits? According to Section 13, a person commits an offense if they use a child in any form of media, right? Use a child in any form of media for the purpose of sexual gratification, right? Using of a child in any form of media, the media may be, let's say, print media or digital media or videography or audiography or whatever. Okay. Use of child for media, any form of media, and for the purpose of sexual gratification, sexual uh, benefit or monetary gains out of that sexual gratification, right? And this includes representation of child's, how it may occur, how this sexual gratification may occur is by representation of, let's say, child's sexual organs, or actual use of children in engaging sexual acts, right? Either in reality, right, person to person, or by simulation itself, right? And this representation is clearly, visibly indecent or obscene in nature. Right? This is what is covered under Section 13 of the statute. This These things apply even if the child is not physically present, right? Even if the child is not physically present, even if the child he himself is not actually getting involved, getting indulged into such kind of an activity, even then Section 13 is applicable. How this is possible? This is possible if the accused is using digitally morphed images, or let's say artificially generated photographic contents. Right? So in these types of situations, even where the child is not actually present or not actually getting involved into the actions, activities, right? But still, the accused can be held guilty. It shall be presumed that the child has participated, and the accused can be held guilty for such an act, right? Now, this section, section 13, doesn't just punish direct abuse, but it also punishes the filming of abuse, storing child pornography. Uh, the punishment which is given under section 13, section 14, clause 1 is minimum 5 years and which may extend up to 7 years, and fine. Fine is compulsory in both the minimum as well as maximum imprisonment. Right. Again, as I said, section 14 is categorized into two parts. The first part is about creating, distributing, and browsing. And the second part, that is section 14, clause 2, talks about uh, if the pornographic material involves actual sexual assault, right? If this material shows actual sexual assault, then automatically the punishment is much stricter compared to the previous provision, right? Right. And the previous sections, that is sections 4, section 6, section 8, section 10, shall also be applicable in this scenario, right? The punishments which are given under those sections will be applicable if there is actual sexual assault that has been created, right, or distributed or browsed by someone, right? Now, uh, the recent developments in the relating to section 13 can be discussed as uh, in context to NCRB, that is National Crime Record Bureau. National Crime Record Bureau as well as Interpol. Right. Now, these two agencies have flagged India among the top 5 countries where child sexual abuse material is being created and circulated. This is quite disturbing for a country like India. Right? India stands to be among the top 5 nations where child pornographic material or abusive material, right, is created and circulated globally, right? Cases involving Telegram, Instagram, dark web, forums are seen to be rising day by day. In one of the cases, the state of Rahul, the state versus Rahul, the case of 2023, a man was convicted under Section 13 for secretly filming girls in a coaching center's washroom. This is something that we are frequently seeing or frequently hearing in the news now and then. But this was something that was discussed in State of versus Rahul, the case of 2023. Right. The court emphasized that uh, even intent to distribute makes it a serious offense, regardless of whether it was eventually shared or not. Right. Even slightest intent may attract Section 13 of the statute. To combat digital offenses, now law and technology, to combat digital offenses, law enforcement many a times also uses the provisions given under the Information Technology Act, like the one we discussed, Section 67B, right, which specifically prohibits publishing and browsing child sexual abuse contents. Right. Similarly, uh, the agencies like the cyber cells and Interpol cooperations, right, to track IP addresses and dark web activities are in place. Right? Now, here, Now we are moving on to into a very, let's say, a practical and impactful part of POSCO Act. That is Section 19 to Section 22, which deals with reporting of offenses. Now, these sections are aimed at not just at punishing offenders, but also creating a more responsive and accountable society, right? Especially among teachers or doctors or NGOs and law enforcement officials. Right? Now, if we talk about mandatory reporting of child sexual offenses, this is kind of a cornerstone that makes reporting a legal obligation. So basically, any person who has knowledge that a child has been sexually abused must report it. He or she must report it to the local police officials, or let's say special juvenile police units, right? Such reporting can be done to these authorities. It's generally the police officials which are very much familiar or very much uh, easily accessible to the general public for reporting purposes. Who are the people who can report such kind of incidences, right? For example, a school teacher. Generally, teachers are very much close to a child and they may have a discussion with the child regarding their family, regarding their parents' behavior, regarding the trauma or the sufferings they are undergoing, right? So, a teacher, or let's say a doctor or a nurse who while diagnosing realizes that the child has been abused, right? So a teacher or a doctor or let's say a neighbor or friend or a classmate, right? Even in some cases a passerby who witnesses something suspicious or who witnesses the sexual abuse marks on a child, right? These people can report to the appropriate authorities. The basic principle here is that no one can remain silent, right? No one can remain silent, especially in case of POSCO Act, right? POSCO cases. Now, if we talk about reporting procedures, the police or the what do you say, special juvenile police units, if it is available within the state, then these authorities must report, must take the report in writing. It must They must read to the informant, assign a unique case number, provide a copy of that report to the other party, to the person who is reporting, and this copy is required to be provided free of cost. And at the same time, they must forward this report to the Child Welfare Committee as well as a special court, right? Child Welfare Committee as well as to the special courts within a span within 24 hours time, right? 24 hours time. Now, if we talk about sections, section 21. Now, section 21, now we'll go into these sections. In short, we'll not go into too much details because there are so many different sections. As I said in the very beginning itself, some of the sections we are going to we had discussion in detail, which were important, and some sections we are going to have an overview. Right. So section 21 talks about penalty for failure to report. Just a minute. Yeah. Section 24, failure to report. Right. So basically, if someone fails to report the act of violence or sexual violence against a child, then the person who is failing to report, can also be held liable under the statute. And the punishment for such person for non-reporting is imprisonment up to 6 months or fine or both. Right? Imprisonment up to 6 months or fine or both. And again, if the person is an authority, right? Or a person is someone who is responsible one, like like a teacher or a doctor, right? Then in that case, the punishment is more strict, right? And the imprisonment may go up to 1 year and fine, right? In previous one, a stranger, if you fail, let's say a stranger, if he fails to report the offense, then the punishment for him is up to 6 months imprisonment or fine or both. But if a person is a responsible person, then the imprisonment may be up to 1 year and fine. Right? This provision under Section 21 ensures that people in positions of, let's say, trust cannot just overlook the other way. They have to act in in this situation. Section 22 talks about penalty for false complaints. Uh, to prevent misuse of POSCO Act, Section 22 is in place. Right? So, if any person knowingly, intentionally files a false complaint, then such person can be punished with an imprisonment up to 6 months or fine or both. But at the same time, here's an important safeguard: the children will not be punished. The children will not be punished for making false complaints under this section. Section 22. Children are not liable for punishment. Now, this protects the best interest of a child. It is possible, it may happen that sometimes the child is confused or, let's say, pressurized. He's under pressure, or let's say he or she is scared, and the law doesn't want to discourage children from speaking up, right? Therefore, children are exempted from filing of from penalty for filing false complaints, right? Section 24 to 27, just a minute. Okay, section 24 to 27 talks about different things, right? uh, these sections basically ensure that children are not further traumatized during the investigation and trial of sexual offenses. Right? These provisions, as you can see, are designed to make uh, the process child friendly, safe, and sensitive in nature. Right? Why child friendly? Right? What is the meaning of child friendly procedures? For this, imagine a situation. Imagine that a child who has just been through abuse. Now imagine being grilled by uniformed police or hostile lawyers, or being forced to the face his or her abuser in the court of law. This would somewhere somehow re-traumatize the child again, right? Now POSCO under these sections ensure that every step of justice, from filing of the complaint to the court of law, to the final decision of the court of law, every step is designed to support the child emotionally, physically, mentally, and emotionally. Right? Section 24 talks about recording of the statement. So basically, the police officer, as we discussed previously, also the police officer should record child's statement at their home. It should be recorded preferably by a female police officer, right? The police officials should be in plain clothes, and it should be recorded by a police officer who is not below the rank of senior inspector. The officer should be child friendly. He should be empathetic. He should be simple. He should be uh, pleasing in nature, and he should not use any kind of a regular tactics like threat, or pressure, which are generally used by police officials. These tactics, these things cannot be used upon a child. Right? Section 25 talks about recording by a magistrate. The magistrate must also record a child's statement as soon as possible, as soon as the offense comes to his knowledge. So the statement should be recorded. It must be recorded, uh, uh, preferably in video recorded format. Nowadays, the video recording is easily available. Everyone has a smartphone. Generally, everyone has a smartphone, so police officials can record the statements in the smartphone as well. So video recording can be done, right, while recording such statement. At the same time, the magistrate must ensure a non-threatening environment. Right? Now, this is important because this helps the right? Child's original version of statement and prevents contradictions at the later stage. Right? It eliminates the aspect of coercion. Right? So important. Section 26 talks about child-friendly trial procedures. Right? When a case comes before the court of law, the special court, right? The court must create a child-friendly atmosphere, right? Like previously, the judge used to wear a wig and a gown, right? Even today, the judges wear long robes, right? The advocates wear long robes, right? So these things are to be avoided when it comes to a child-friendly trial, right? Basically, unnecessary legal drama, right, should be avoided in a POSCO case. At the same time, the child should be allowed to testify via, let's say, video conferencing or let's say behind a screen so that they don't face the accused directly, right? The court at the same time must also allow aggressive or the court must not allow the advocates to exercise aggressive questioning, right? Or suggestive questioning, or the questioning which are generally meant for the adults, not for the children, right? The children may not have that kind of a vocabulary. So such kind of questions are to be avoided when it comes to trial involving a child, right? And at the same time, the trial must be completed within 1 year. Important, 1 year from the date of cognizance of offense. Okay. Now, section 27 talks about medical examination of the child. Now, this section ensures that medical evidence is collected with proper dignity and care, and it should be collected by competent authorities only. Right? Now, this collection of medical evidence should be done within 24 hours of the report. It should be done preferably by a female doctor. At the same time, if the child is below the age of 12 years, a guardian, let's say a parent or some trusted adult person, right, should be present at the time of medical examination of such person, such child who is below the age of 12 years. The doctors must also take consent of the guardians and in some cases consent of the child. Of course, if the child is old enough or mature enough to give the consent, right? And explain these people, either the guardians or the child, as to what is happening in the medical process. That is also important. That is also covered under section 27 of the statute. And not only section 27, but in some of the case laws as well. Like in case of State versus Sham Babu, right? The case of 2021. The Delhi court refused to accept in this case, refused to accept evidence in this case that was taken in violation of section 26. Right? The In this case, that it was found by the court that the child was questioned very harshly, and that too in front of the accused. Right? Therefore, the court refused to take cognizance to take cognizance of the evidence which was presented in this case. Right? The court in this case said that POSCO is not just about punishing the abuse, it is about protecting the child even during the judicial process. Right? Even during the judicial process. Now, these sections, section 24 to section 27, reflects more of a compassionate spirit of POSCO Act. Right? So basically, justice should not cost a child their emotional peace. Right? So this is about section 24 to section 28 of the statute. Now, if we talk about section 28 to section 32, these sections primarily focus on the establishment and functioning of special courts, right? Establishment and functioning of special courts. Uh, at the same time, the sections also talk about compensation, right? Compensation provisions are also given under in these set of sections. Now, these sections play a very important role in ensuring that the entire legal process under POSCO is streamlined and that the children receive the necessary support and justice in a sensitive and effective manner. Now, if we talk about Section 28, establishment of special courts. Now, what is the purpose of Section 28? Special courts are established for the trial of offences under POSCO Act. Is one, right? Now, the idea is to ensure that the child uh, who is sexually assaulted, abused, right, or the child sexual abuse cases are handled with are handled speedily and sensitively and by the hands of the expert. Right? Therefore, these courts are meant to be child friendly. Right? Not every criminal code is child friendly. These courts are meant to be child friendly and ensure that trials don't go on for years and years. And that's something that we generally see in either civil cases or criminal cases. Right? Uh, if the cases are going on for years and years, it will simply amount to, let's say, re-victimization. Right? Re-victimization will may happen uh, of the victim itself, right? So if we talk about the features of the special codes, then they are fast tracked. They follow fast track procedures, right? They follow in camera trials, and there are expert judges to deal with the matters relating to POSCO. Okay. Section 29 talks about presumption of guilt in certain cases. So basically, if the accused is found to have committed an offense under, let's say, Section 3, that is penetrative sexual assault, or let's say Section 9, that is aggravated sexual assault. The law presumes that the accused is guilty unless proven otherwise. Right? The law presumes that the accused is guilty. This is very rare, right? Otherwise, the law generally presumes accused to be innocent, and it is the prosecution who has to prove that the accused is guilty. But here, under section, let's say 3 and section 9, the court presumes that the accused is guilty. Now, this section shifts the burden of proof onto the accused. Now, the accused is required to prove that he is innocent, right? Particularly in serious cases where evidence is very much compelling in nature. Section 30 talks about powers of the special court. Now, this section grants wide power to the special court. Uh, this power is granted to ensure that the case is conducted efficiently and with dignity of the child. To While exercising this power, the court can accept, let's say, testimony via video conferencing. It can relax certain rules of evidence, right? Strict rules of evidence are not followed. Strict procedural laws are not followed uh, uh, in the POSCO cases, right? The court is also responsible for ensuring that compensation is awarded to the child in case of victimization, right, wherever necessary. Section 31 talks about court procedure and powers, right? So, special court uh, is granted special powers to give protection to the child during the entire trial of the case. It is the duty of the special court, rather a duty than the power. It is the duty of the special court that to ensure that the child is not confronted with the accused in any intimidating manner. The special court is required to ensure that the trial is completed within 1 year from the date of filing of the charges. Right. So, if you look at the recent recent changes or updates that are happening in the field of POSCO or POSCO, or rather the trial uh, before the court of law, is uh, electronic evidences, right? Electronic evidences. Now, the digital recordings or the mobile phone contents is now regularly used in cases, and the court in such type of cases must ensure that it's admissible while protecting a child's dignity. The court may also involve a child welfare expert or a psychiatrist to assess the child's emotional state before proceeding any further, right? So the help of, let's say, NGO or a child expert or a psychologist or psychiatrist can be taken by the court of law. That is the authority that the court has. Then if we talk about section 32, that is the right to appeal. This section ensures that both, not only the accused, but both the victim as well as the accused have right to appeal against the decision of the special court. The victim, through his public prosecutor, can appeal against the acquittal or lesser sentence awarded by the special court to the accused. Similarly, the accused also has a right to challenge their convictions or challenge the sentence that has been imposed in such convictions. Right. Now, if we talk about the time frame, then appeal is required to be filed within 30 days of the decision of the special court. Within 30 days, right? That is provision relating to appeal. Now, let's talk about section 33 to section 38, that is uh, procedure and powers of special court and recording of evidence, right? This set of sections, section 33 to section 38, these sections basically focus upon uh, the trial process, the child safety, uh, uh, the proceedings relating to trial of the case, the compensation aspect of it, confidentiality, uh, then media restrictions, and so on. Right? All these are covered under this set of sections, section 33 to section 38. Right? And these sections together somewhere somehow are uh, ensuring that the trial is very much child centric in nature, right? Child centric trial or child centric justice is provided in the in POSCO cases. So section 33, procedures and powers of special court, this is something that we have discussed previously also, right? So again, the same thing is mentioned somewhere. very much similar thing is mentioned under section 33 as well. That is, a child cannot be exposed to the accused, or the child must not be called for repeated testimony, right? Unless it is necessary, the child cannot be called for repeated testimony. Then again, the child is not harassed during cross examination by the counsels, by the advocates, right? That is something that is covered under section 33 of the statute. At the same time, the child should be given proper care and proper support, right? Support of person like his parents or the guardians during the entire trial itself. So these are some of the provisions which are covered, things which are covered under section 33. Now section 33 8, section 33 subsection 8 of the statute talks about victim compensation. This is important, right? So section 33 subsection 8, victim compensation. Now this subclause empowers a special court to recommend compensation to the child victim, for, let's say, medical expenses or rehabilitation and loss of educational opportunities and so on, right? Or for all these and any other aspect of compensation can be covered under section 33, clause 8 of the statute, right? Now, again, one more important thing regarding compensation is that compensation can be awarded in addition to the punishment, maybe imprisonment or fine or both. So, compensation can be awarded in addition to the punishment that has been awarded to the accused. Section 34 talks about joint trial. Now, this section allows that if a person is charged under POSCO Act or IPC or any other law, all offenses may be tried together in one trial, right? All these offenses can be tried under one trial itself. So it is basically section 34 talks about joint trial. Section 35 is timely disposal of cases. So this section mandates that the special courts record the evidence. The recording of the evidence must be completed within 30 days, right? 30 days from the date on which the court takes cognizance of the case. And at the same time, the entire trial of the case must be completed within 1 year, right? 1 year of the date of taking of the cognizance. This section 35, ensures that speedy justice is provided to the victims under POSCO Act. Section 36 talks about not to expose the child before the accused, right? This is something that we have already discussed. Section 37. So, section 36, that the child should not be brought before the accused. If at all he is required to be brought before the accused, then some kind of a curtain or some kind of a screen should be used, or a video link testimony should be used by the court of law. Section 37 talks about in-camera proceeding. It means that no public access to the trial should be allowed, right? Only the necessary parties to the case, that is, let's say, the judges, the counsels, the lawyers, the accused, the child or the victim of the act of abuse, and the supporting persons like the guardians, etc. Such type of people only can be allowed. The clerical staff of the court, such kind of people can be allowed in a trial relating to POSCO, right? This somewhere somehow protects the privacy of the privacy as well as the dignity of the child. Then comes section 38, that is media restrictions. So again, any kind of media publicity of the POSCO cases is strictly prohibited. So photography, publication of names or addresses or school details, etc., are strictly prohibited under section 38 of the statute. If any person If any media house publishes such kind of detail, then such person may be given an imprisonment of 6 months and a fine. Okay, so uh, here we are coming to the conclusion of our session today. So basically, in conclusion, we can say that the POSCO Act of 2012 is not just a legal framework, it is a moral commitment. It is more of a moral commitment to protect the most vulnerable member of our society, that is, our children. Now, this statute somewhere somehow acknowledges the unique needs of a child, right? Especially the child survivors, and it strives to deliver justice in cases of abuse or assault. The POSCO Act strives to deliver justice that is uh, swift, swift, that is sensitive, and that is child centric in nature, right? Through its uh, provisions from defining offenses and establishment of special codes and ensuring privacy and dignity of the victims under POSCO Act, at the same time rehabilitation, compensation, and a trauma-free legal process. Right. Apart from all these things, the Act also stands a strong message that sends a strong message that a child's safety is of paramount importance and is non-negotiable in nature. But the real power of POSCO lies in the implementation of the Act, right? Implementation of the Act, and that responsibility somewhere somehow lies upon all of us. So, as let's say, as a legal professional, me as a legal professional, educator, and others in the capacity of caretakers, guardians, or at the most, the citizens, it becomes our responsibility to protect a child from such kind of uh, heinous act of sexual assault or sexual offenses, right? So, with this, I hereby conclude my session, and I thank you all for your for listening to me and viewing this video. Okay, thank you.